So the issue of privacy has already come up a couple of times today, and so who better to discuss the different approaches to privacy regulation than the different people who regulate privacy. So I will just quickly, you can't, okay, can you hear me? All right, well fortunately it's not me that you need to hear from. But I'm going to quickly introduce the moderator and she will take it from there. So Julie Brill, our moderator, served as a commissioner at the Federal Trade Commission from 2010 through 2016. After leaving the commission, she became the co-director of the global privacy and cybersecurity practice of Hogan Lovells. And I believe just a few days ago, on August 14th, she became the corporate vice president and deputy general counsel for global privacy and regulatory affairs at Microsoft. And so, Julie, please.
Thank you. Thanks so much, Scott. And, oh, now that's a little too loud. Oop, there we go. So it's my great honor to introduce two of my dear friends in the privacy regulatory space. And we're going to have a conversation here for a little while and then open it up for some questions from you. First, Maureen Ohlhausen, who really needs no introduction because so many of you know her, but just in case one or two of you have been living on the moon for a while it was passing over the sun. For 4 years, Maureen and I were commissioners together on the Federal Trade Commission. Since January of this year, she has been acting chair. And we just learned a day or two ago that she is now the longest acting chair in FTC history.
So, I don't know if that's something to brag about.
Yeah. As many of you know, prior to that, Maureen was at Wilkinson Barker, heading the FTC practice. She also ran the FTC's Office of Policy and Planning prior to being in private practice. And then prior to that, she was serving on the DC Circuit for 5 years as a clerk, including to Judge Santel. And on my left is Giovanni Buttarelli. Again, for most of you, doesn't need any introduction, but again, for those few of you who may not know, he is the European Data Protection Supervisor. That is an independent institution established by the Lisbon Treaty. He ranks as a commissioner, although he is independent. He also serves as a member of the Cassation Court, did I pronounce that correctly, in Italy. He is a special advisor to the EU Parliament and to the EU Council. He is also part of the Article 29 Working Party. In addition to his duties as the European Data Protection Supervisor, Giovanni has been the Secretary General of the Italian DPA. He served as the Italian DPA for 12 years, and he also, prior to that, was in the Ministry of Justice in Italy doing all sorts of incredibly interesting things. So we're going to kick this off with each of them, Maureen and Giovanni, giving some opening remarks about some of the top issues that they and their agencies will likely be facing over the next year or so.
Great.
Maureen, would you like to start?
Sure, thank you, Julie, for that wonderful introduction. And Giovanni, it's great to be on a panel. Giovanni and I have been on many panels together. We've had lots of good discussions.
Indeed.
And it's really nice to be back at TPI in Aspen. It's an incredible setting here. I think if I get stuck on any question, I'll just look to the hills for my deliverance up there. It's I've never had such a beautiful setting to speak in front of. So as Julie mentioned, I have been the acting chairman of the FTC since January. And I came in with the goal of having a strong, positive agenda to get some things done. So let me give you some of the highlights of things I've really been excited about working on. So my signature effort is my Economic Liberty Task Force at the FTC, and I was delighted to hear Deirdre McCloskey's remarks this morning because they so closely echo the sentiments that I feel about how do we allow job growth? How do we allow innovation? How can we spur greater job mobility and opportunity and just basically innovation and output in the US? And so one of the things we're really focusing on is occupational licensing. And this has been a wonderful bipartisan issue at the FTC for many years. Julie and I have supported many comments in this area. The Obama administration did a terrific report on this. Lots of groups are paying attention to it. And I'm really heartened to see so many people across the political spectrum joining the movement to focus on why are we requiring so many people to have a permission slip from the government to do their job. And one of the things I saw just last week was about an article about how this can even impact high-tech and innovative jobs as long as more traditional occupations. So we often think about hair braiders and tree trimmers and some of those things, but this can also be an issue in the high-tech area. So in addition to occupational licensing and economic liberty, I've also focused on regulatory reform and streamlining the agency. The mission of the FTC is to promote competition and to protect consumers, but also to do so without unduly burdening legitimate business. And so that's one of the things I try to look at is, are we operating in ways that put these undue burdens, and can we slim things down, make things more accessible, make things more understandable for business as we can still be a good steward for protecting consumers and competition, but do it in a more efficient way. I've tried to increase guidance on data security. We get this question all the time. Is there more guidance? Can you do more things? So I started our Stick with Security series. We have a blog post every Friday that talks about, we have Start with Security, which gives companies guidance based on enforcement actions that we've brought. And I thought, well, but we close a lot of investigations because often we find the company has taken reasonable precautions, that the data breach or the problem that was reported in the press ultimately didn't rise to being a violation of the FTC Act. So are there principles and guidance that we can distill from that to give additional guidance to companies? So we're working on that. We explored our data and data security and privacy issues in a connected car workshop earlier this year. And I did want to point out, I thought it was interesting when we're having the discussion about connected cars, that in some ways it's easy to focus on, well, will it reduce traffic deaths? But the other thing is the incredible benefits that it'll offer to people who are handicapped. My own mother has always had a very disabling vision condition, was never able to drive her entire life. And so kind of opening up mobility for these kinds of folks, also allowing people to age in their own homes, right? Because as we know that driving can become more difficult as we get older. Are some of these inventions, technologies, innovations going to allow people to have a better quality of life? So it's not just a binary, do you live or die in a traffic accident, but I think that there's a lot more benefits to be had. The FTC staff and I filed substantive comments with the FCC supporting the return of broadband to light touch non-common carrier Title I classification. And we've done a number of other collaborative efforts with the FCC on robocalling and privacy and security. On talking about privacy in particular, just last week, we brought an enforcement action against Uber, and we settled with Uber for privacy violations, for violating privacy promises that they had made about who within the company would have access to riders' data and also drivers' data, and that there had been a breach there. So we put them under an order, and they have reporting obligations and privacy audits that they're going to have to do. We're going to talk a little bit more, I think, about Privacy Shield, but that's also been a big topic of conversation at the FTC, carrying out our obligations under the Privacy Shield agreement. In particular, so moving away from Privacy Shield and just privacy more generally, I have a particular interest in, now that we have brought a lot of enforcement, kind of straightforward enforcement actions in the privacy space for things that like expose account numbers and kind of real-time location, what other types of harms should we be recognizing as a harm in a privacy violation? So the Bureau of Economics at the FTC has done an interesting paper on the economics of privacy, and I'm going to be exploring more deeply what I call informational injuries. How do we determine what is a substantial injury from the release of information such that the FTC should be taking action? And then, of course, we were always going to do our bread and butter fraud enforcement. We continue with that quite actively. And one of the questions I often get, and I'll finish on this and then turn it over to Giovanni, is, so right now at the FTC, we have myself and my fellow commissioner, Terrell McSweeney. So we have one Republican and one Democrat. And so in the popular narrative, that means we must be in total gridlock and we can't get anything done. But actually, we have had more than 200 unanimous votes on matters before the FTC. We've brought very important enforcement actions. We've had testimony. We've do a whole host of things, and we've been able to keep the agency going, keep protecting consumers and protecting competition. And so, believe it or not, it can work in DC. So.
It's amazing that 200 votes just in a few months.
Yes.
It's amazing. Most people don't realize how much the commissioners actually have to push through and work on. Thank you, Maureen. Giovanni, you want to give us your vision, your overall vision of the next year or so for you?
Thank you, Julie. Needless to say, first, that I'm grateful to TPI, Scott, and his team for your very kind invitation. I see a few other European faces around, but I guess to be the only speaker. And this makes me so proud to derogate to the dogma, the EU dogma that no business can run in August, first. Second, to speak in business casual, no business attire, and additionally, no blue tie. So hope that you colleagues, by looking to the video, will not have after the eclipse a collapse. Having said that, as you know, the European Union has been through a long period of reflection on how people should be better treated with respect to the new digital reality. And our privacy and data protection laws were out of date, and they needed to be updated. We did it with the regulation, which, according to the Lisbon Treaty, is a robust legal framework. European Union is not a federal state, it's a separate entity, but the impact of such a new regulation is something similar to a federal law in the US. So you will have, for privacy and data protection, a fully operational new legal framework which works, in my view, for also big data, artificial intelligence, and new analytic techniques, fully operational as from the 25th of May next year. And this is not simply about technical innovation, so new rules on profiling, right to be forgotten, and so forth and so on, and portability. One of the big changes relates to accountability and therefore how you should demonstrate that you go beyond mere compliance. So speaking about priorities, I will serve the newly established European Union board, which will replace the current working party which gathers privacy and data protection authorities in the EU. I will be a full member of this group, but also I will provide the secretariat, and this is why my relatively young institution is growing. And therefore, we have to be prepared for such a big change from a purely advisory body to a decision-making body, taking also binding decisions towards national authorities for cross-border processing activities. And such a transition aims now to improve the consistent application of this new regulation. And we have to take, as a European Data Protection Supervisor, all necessary steps to ensure that as from 25th of May, we will be ready. But the challenges are not only around the new rules. As you know, Europe should also pass a broader regulation dealing with e-privacy, few provisions aiming at particularizing and complementing general data protection regulation. There are expectations to reopen the discussion, but this will not happen. The European Union legislators are exhausted. The first one speaking about changes to the regulation will be shooted in Place Luxembourg without any appeal. And I mean, the success story is around the the substance, because differently from it may appear from this side of the ocean, the GDPR, General Data Protection Regulation, is not the one of my dreams, is not the perfect one, but even if we start again with other 4 years of amendments and discussions, we will not have something better. And therefore, we have to be satisfied about one of the main successes of my, let's say, advisory role. 25 out of 47 provisions speaking about additional rules have been replaced by focusing on flexible guidance by independent regulators. This will allow us to be more, let's say, conversant with the business sector. We have to, before adopting this guidelines, we have to launch public consultations and take utmost account of the relevant comments. We started doing this with regard to the notion of lead authority, competent to adopt one binding decision for cross-border activities, and also on few relevant issues concerning, for instance, profiling and consent. Data protection rules are challenged by the data-driven life, and this is why, in my view, big data, artificial intelligence, robotics can be considered as the fourth industrial revolution, to be compared to the second one in the 18th century, where a debate took place about dignity. It's time for a discussion about to which extent data protection rules can solve all the issues, perhaps not. And therefore, we need to think in terms of longer perspectives, broader context. And this is why I have established an independent advisory group at my institution. We entered into a privacy debate by an ethical viewpoint. We hosted workshops, and we are committed to bringing the debate further. The advisory group will publish its report soon, and we hope to, let's say, have a conclusive debate next year, where the Olympic Games of Privacy and Data Protection will take place in Brussels within the European Parliament plenary room. I will be the co-host together with the Bulgarian colleague, and it will be dedicated exactly to the ethical dimension. So you are all invited to attend the public session. As from the 1st of May this year, I am the supervisory body of the European Union FBI, Europol, and this is a big challenge for the next few months to demonstrate that in a particular difficult moment in terms of security threats and terrorist attacks, you are all familiar with recent news from Barcelona, we may be, say, efficient and identify the right balance in between security, also by cyber attack viewpoint and data protection. Finally, we are working hard to prevent that all relevant provisions by data protection viewpoint, consumer protection, and competition approach are less applied in silos. This is why we established a digital clearinghouse. It's a network of independent authorities willing to cooperate on common issues for the digital market. It does not interfere with other important existing networks, but rather will aim to, let's say, tie them and add those projects value. And regulators already got to work in May. A qualified representative from FTC was also present. And they showed a lot of curiosity towards the initiative. So we will continue working in that perspective, and we are confident to bring further this exercise through 2018.
Great, thank you, Giovanni. All right, well, Maureen, you've already mentioned Privacy Shield. For those of you who may not be aware, Privacy Shield is an agreement between the United States and Europe about data transfers. It's designed to replace the safe harbor, which was in place for 15 years, clearly needed to be updated. And while those discussions were underway to update that, it was struck down by the European Court of Justice. So Privacy Shield is in place. Part of Privacy Shield and a very important part from the European Data Protection Authority's perspective was to require an annual review of the process. And that annual review will be taking place in September, just next month. So let's talk a minute about that. Maureen and Giovanni, but Maureen first. If you could address, what do you think are the next steps with respect to the Privacy Shield review? What do you see as the primary issues that are going to be in contention? What do you think the outcome will be? And if it's different, what do you think the outcome should be? So talk about that a little bit.
Sure. So I think one of the things that is going to make our agreements more robust, the difference between privacy, the safe harbor and the Privacy Shield, is having this review. And the aim is really to see if there are any issues that are arising and to have a mechanism to explore these. As you mentioned, the safe harbor lasted about 15 years. And it was in need of some updating, so kind of build in a mechanism to have those discussions on an ongoing basis. And as part of our commitment to the Privacy Shield, the FTC is committed to participate in this review next month. So we expect that the review is going to look at the administration and enforcement of the program. Another important part of it is consumer education on both sides of the Atlantic. Do consumers in Europe know that they have this option available to them, that they can call upon Privacy Shield to give them rights to raise concerns and to get more information? So we're going to review how the U.S. agencies and our European counterparts are cooperating and see if there are ways that we can improve that. We'll also discuss some developments in U.S. law. Now, even over the past year, we've had a bunch of discussions with various European officials. I've met with some and other folks at the FTC, and topics have included things like executive orders or changes in the broadband privacy at the FCC, and we've discussed these already, but we're happy to discuss them more. And then one specific topic that was highlighted as Privacy Shield was announced was to have a conversation on the European concept of automated decision making. And we expect to discuss U.S. approaches in this area, such as our Fair Credit Reporting Act protections, and how there may be some similarities between the European views and approaches and ours. Now, one thing I will note, the FTC is not a national security agency. Part of Privacy Shield does include national security and law enforcement aspects, but the FTC doesn't play a role in that part. And then formally, what we expect the output will be a report by the European Commission to the European Parliament and Council, and the data protection authorities have announced they may also have a report, but Giovanni can probably provide further details on that. Now, I'll also mention, the FTC was an active enforcer under the Privacy Safe Harbor, and we continue and will continue to play that role in Privacy Shield, so stay tuned in that space.
Great. Okay. And Giovanni, I'd love to get your perspective on on all of this. What will be the issues from the European perspective? What will be the outcome? What should be the outcome? But also, I want to note you've recently spoken about this issue about Privacy Shield and have said that you think it will be a temporary mechanism, and that we ought to ultimately be looking elsewhere in terms of guaranteeing to Europeans protection of data as it gets transferred. So if you can also touch on that a little bit, I think people would be very interested.
Yes, I will. But let me start by saying that my institution will actively take part of the joint review, which is likely to take place in a month. And we expect some very positive signals. So your administration is known for, surprise people every day, and we expect some positive signals in that sense. We need of some signals because the Privacy Shield depends on assurances provided by the outgoing Obama administration, and it replaces another similar legal instrument, the Safe Harbor, which has been annulled by our European Union Court of Justice because it was not considered as properly implemented, and it was considered as being in a sort of dead waters, particularly, though not only by the surveillance part. The Privacy Shield contains a lot of improvements, particularly on the commercial side. But regardless of the short-term future of this legal instrument, we need, in my view, of a longer-term solution based on mutual respect and common understanding. And we need to better allow people to understand to which extent they are entitled to expect from anyone who is processing data respect. Why it is an interim instrument, in my view? Today, our legal framework provides for application of our rules to people established in the EU. And therefore, anytime you have to demonstrate that a company is established or not. And this is a difficult exercise. Then if you transfer the data to the US, you can now build on the Privacy Shield, but it only covers one processing operation, which is the transfer of data. As from the 25th of May next year, and this is relevant not only for big companies, the scope of application of our rules, and this is an approach now relevant for Europe, but is likely to be relevant for many other third countries, will be different. So we will apply our rules regardless of where the headquarters, the servers, and the offices are. So we will look to the place where the services are offered, where goods and services are offered, even remotely, or where people is when it is profiled. And you may easily realize to which extent it's difficult for big companies operating around the world to have a different privacy policy depending on the regional approach to Europe or on other countries. So there is a risk that we export our data to other players in the world, and this is why I'm encouraging third countries, including the US, to realize that it's time for a change. But of course, we have to work in two steps. A short and mid-term solution. We need to keep this legal instrument as properly implemented and to start thinking to a more robust perspective. In that sense, if you allow me to paraphrase Mr. Kissinger when he was likely to say years and years ago, who we should call in Europe when we have a problem.
Right.
We would like to have now 2-3 phone numbers in the US anytime we have a privacy issue. So I believe in terms of positive signals that although privacy and data protection cannot be considered necessarily a priority for this administration, relevant appointments concerning PCLOB, FTC, but also the ombudsperson at the State Department will be completed soon. Not speaking about people in the Department of Commerce in charge of the day-to-day business. If not, let me say very frankly, the Privacy Shield is at risk as it was the safe harbor. There is already a court case concerning standard contractual clauses, and it may be relevant for Privacy Shield soon. So we have all the relevant chances to prevent another bad story.
Okay, so just to clarify, because you mentioned at the beginning of your very helpful remarks that Europeans need some signals. So you came back to that at the end, and you mentioned some appointments that you believe need to be made, including to PCLOB, getting the ombudsman to be putting a permanent person in that position, the FTC vacancies. Are those the kind of signals you're looking for?
These are an essential part, but not the only one.
Yeah, what else?
The main emphasis is about the way in which the assurances provided by the Obama administration and included in a list of annexes to the Privacy Shield are a reality in practice. Because right after the adoption of the Privacy Shield, the community of data protection authorities adopted a document to say, okay, we appreciate the improvements, but we would like to, let's say, see a few other, let's say, clarity around the way in which these principles are applied in practice. So the joint review is a unique opportunity to provide this clarification.
And my understanding is Commerce Secretary Ross has confirmed that this administration is supporting all of those principles. Is that your understanding?
Yes, absolutely.
Maureen?
He has said that. For my part, speaking for the FTC, the fact that we now have 2 commissioners doesn't really impact our ability to enforce or interest in enforcing privacy promises. I mentioned we're continuing to act and bring cases. So we have a fully staffed bureau, and they're continuing to bring enforcement. So certainly, I would love to see more, appointments in the P Club and some other areas. But sometimes I think there's a misperception that because we are made to have 5 commissioners, that we all split the work 20%, 20%, 20%, and that somehow that other 60% isn't getting done. But Julie, you well remember, we all review everything and vote on everything. So.
That's exactly right. And if you need some phone numbers, you can call me.
Okay.
I'll get you phone numbers.
Yes.
Okay. I'm just kidding. It's actually a very fair point, I think. Okay, let's turn a little to some sort of broader questions. Giovanni, you already touched on the General Data Protection Regulation in Europe. I think probably most people here are deeply familiar with it. It is law in Europe, so it is not, even though it's called a regulation, it actually has the status of a federal law. And it is extraterritorial. It has long-arm jurisdiction, as Giovanni also mentioned, so that companies must comply with it even if they're not located physically in Europe, as long as they are processing or controlling data about Europeans. And that means many, many more companies are going to be covered by GDPR than were covered by the prior directive, the Privacy Directive. I also will note that some of Giovanni's colleagues, like Bruno Gencarelli of the European Commission, when he has come to privacy events in the United States, he has been amazed at the level of recognition of the need on US companies' parts to comply with GDPR. Indeed, I've heard some European officials say that more US companies seem to be paying attention to it than European companies are paying attention to it. So there's a really interesting phenomenon. But what I want to talk about is bringing the GDPR as well as the FTC Act into the kind of conversation we were having this morning about AI, about connected cars, about IoT, and the extent to which GDPR as well as the FTC Act are fit to purpose for being primary sources of regulation for these innovative areas. Giovanni, I'd like you to go first, and as you and I were talking about last night, I have heard from some scholars in Europe that GDPR is great when it comes to process. You need to give consumers or data subjects lots and lots of process. You also, as a company, need to have accountability, which is a process-oriented approach. But there's a little bit of concern. I'm not suggesting that anyone go and try to pass another law. As you were saying, everyone's exhausted at this point. But there is some concern that there's no underlying girder of fairness in GDPR. So the question becomes, is GDPR fit to purpose for AI? Is it fit to purpose for IoT? GDPR also has some interesting provisions in it that have really nothing to do with privacy, like data portability, which is really a competition issue rather than a privacy issue. But tell me what you think. Will Europeans be able to focus and have some sort of oversight of AI in an appropriate way?
The answer to your question is yes, but before going into details, I have homeworks for all of you, since I produced for the last international conference of all data protection, privacy and information commissioner in the world, a document which is published on the website of my institution, EDPS, to focus on the challenges for data protection for artificial intelligence, robotics, and big data by a data protection viewpoint and by a global viewpoint. This is not only a European Union document. It aims to demonstrate that we don't want to slow down innovation, but of course we are aware that on one side, big data is deeply implicated by artificial intelligence. They have a sort of bi-directional relation, as artificial intelligence through machine learning needs a vast amount of data to learn. On the other hand, big data uses machine learning to extract value from data. The success story of the GDPR is around guidance. So there are no provisions speaking about artificial intelligence or robotics. And I know that some distinguished experts are saying that in a few years we will do it. But remember my example about the shooting exercise in Place Luxembourg. So I think we will work on the several provisions which are directly relevant for artificial intelligence and big data, particularly those on transparency and information. So to allow individuals to better understand what happens about decisions taken about them and to have a different kind of control around the processing of personal data. At the recent CPDP event in Brussels, you, Julie, wondered how to effectively, let's say, apply and deal with the complexity of artificial intelligence. And you say perhaps the solution is very pragmatic. So we should be transparent on the initial output and on the final input and on the final output, while the legal framework provides for transparency for the whole process. This is one of the challenges. I launched the mantra that data protection should be digital, and I'm not a member of the conservative club by data protection viewpoint to say we don't care about new technologies. Anytime there is a new technology, there is such a matter we have to change. We continue applying our rules and we don't care. Others are predicting, let's say, other approaches where we should anytime enter with a regulatory approach. I think we should be flexible, pragmatic, we should be dynamic, we should focus less on requirements and more on safeguards, and to be proactive and dynamic enough to identify new modalities to make existing principles more effective in practice. Our principles in the EU, which are very similar to your basic principles in the US, cannot be rediscussed because they are now focusing in the Lisbon Treaty, and regardless of the Brexit, they will stay there for years and years and years. So the question is how we may make these principles more effective in practice, how we allow artificial intelligence and big data to take off.
Yeah, and my comments at CPDP, which is a very important event that takes place in Brussels, were really to counter those who are calling for algorithmic transparency, and I was trying to explain that algorithms change moment by moment. I mean, and they're constantly evolving through machine learning, and to have transparency around the actual algorithm would be a very, very difficult thing to do, number one, and number two, for anyone to actually understand what it means, which is why I was focused on inputs and outputs. Maureen, when we wrote our IoT report, as well as our big data tool for inclusion exclusion report, what we focused on was the fact that the FTC Act is helpful, but there's this whole other matrix of laws in the United States to deal with some of the fairness questions, like the anti-discrimination laws and whatnot. While, of course, we were also saying we need to promote innovation, we don't want to use a heavy hand, but there was a safety net of rules in the United States that dealt not just with privacy, but also some of these other effects that were potentially out there. So what do you think? Are we going to be able to handle this new world going forward?
I mean, I think so, and you raise a good point, because so often this debate takes place in the idea that it's the Wild West and there's no rules and we're all kind of starting from scratch, and that's just not true. So you look at the Fair Credit Reporting Act, and a lot of the debates that we're having now and the discussions we're having now about saying some computer somewhere is going to be getting these bits of information about me and making a decision about me that's going to affect my ability to get a job or my insurance or something, buy a home. So actually I have an article that talks about this and goes back and looks at them and says the hearings before Congress, these exact same things were being said way back then. So that I think is heartening, because we can say we have faced these kinds of challenges before, and we've come up with ways that allows innovation to happen and benefits to happen while still having protections for consumers. We have anti-discrimination laws. We have special laws about children's information and about financial information. But the FTC Act really is very, very flexible. So we prohibit deceptive practices, deception, or unfair practices. And what's unfair? It's an act or practice that causes or is likely to cause substantial harm to consumers that the consumer can't reasonably avoid and that is not outweighed by countervailing benefits to competition or to consumers. And so that has allowed us to have a very flexible case-by-case enforcement approach that's really tied back to this idea of harm, but still weighing some of the benefits, right? Because it's kind of a cost-benefit analysis. So when we're talking about things like the Internet of Things or big data, we need to look at all those other possible benefits and then ways that we can consumers can protect themselves or laws that already exist to protect these things. So one of the things that I found as we're talking about big data and artificial intelligence, which just seems to be sort of another iteration of big data, is how should we look at this? And tying it back to a consumer harm framework, I think, is a very useful way to look at it. Because when we use deception, and you say, okay, you made a promise about safeguarding this data or not collecting certain types of data, that's fairly straightforward. But when you're talking about unfairness and substantial injury, I think that that has a lot more capability to reach the kinds of issues that I think people are beginning to be concerned about, which is a whole bunch of non-sensitive data was collected in a bunch of different ways in a bunch of different data sets and different forms, and now it's being assembled and artificial intelligence or big data techniques are being used to extract new insights out of that. And a lot of those insights will be incredibly beneficial, right, to consumers. They may say, you're at risk for cancer you realize you're at risk for, or here's a product that would suit you really, really well. But it also could be used to harm consumers. And this kind of goes back to the Fair Credit Reporting Act idea. Are there uses of this data that could harm consumers? Obviously there are. How do we handle that? Under the Fair Credit Reporting Act, we said, well, having someone know I have bad credit could harm me, but it might benefit society overall because credit will be priced appropriately. So what do you do there? Well, you give consumers insight into what that data is. Was that decision being made based on that data? The right to correct it, those kinds of protections. So I think that as we're talking about big data and artificial intelligence and kind of what's the right regulatory framework, I think the FTC Act provides a lot of useful guideposts. Rather than having a regulation that tries to predict every new technology and every new use of data, that kind of ties it more back to, well, did you make a promise that you didn't keep? Well, that's pretty straightforward. Or is this data going to be used in a way that harms consumers? So later coming up, I hope that we at the FTC will be able to do a little more thinking. I mentioned informational injury. That's something I want to talk more about, but also on artificial intelligence, because it has a consumer protection element to it, but it also has a competition element to it. There are concerns about the ability of algorithms to engage in collusion for price fixing and things like that a lot more quickly and in a way that might be harder to detect. And so that conversation, believe it or not, is going on in the competition circles as well. So I'm hopeful that at the FTC we'll be able to delve a little more deeply into kind of using both sides of our mission to look at artificial intelligence.
So many thoughts come to mind to follow up on both of those comments, but in the short amount of time that we have left, why don't I open it up to you all? Let's take three or four questions all at once, and then I'll ask our wonderful speakers here to respond to them. So does anybody have a question, comment? Hopefully making it a question at the end of the comment. Anybody? Yeah. Whoop.
Can you hear me? Oh, no, you can hear me. My name is Wolfgang Kopf, Deutsche Telekom, so I'm one of the few Europeans in this circle. Giovanni, you were referring on the end of regulation at the moment in Europe, but there's a piece of regulation going on which is rather scary, and that's the EPrivacy Regulation. And you're advising the European Parliament on that. What's your advice? Because the current state of that regulation would lead to tightening rules on data lakes, on data analytics, and also on the entire data business, not only for telcos, but also for OTTs like Google, Amazon, whoever.
Let's grab a couple of other questions, and e-privacy is obviously very important. Anyone else? Come on. Yeah, easy.
My question is about really the continuous nature of regulation or these principles versus doing it and then saying, okay, we are not going to be updating again. Because as somebody coming from the AI world, we are understanding the issues as we apply these technologies in different ways into different verticals. So to me, it looks like there needs to be a continuous discussion as technologies get applied to the real world, and these processes maybe need to be repeated continuously. What are your thoughts on that?
And if I could add to that, that's a great question. That also pops up in the security realm too, right? When we had that conversation about IoT security an hour or so ago, where, how can laws keep up? So what are the other mechanisms that we need to have in place to deal with security? One more question? Anybody? Yep. Yeah, Nicole.
Hi, Nicole Turner-Lee from Brookings. So the question I have is sort of directed at acting chairwoman Ohlhausen on algorithms. Do you see going forward sort of this continuation of a discussion on principles and maybe value framework around algorithms, and what, President Obama started with sort of this framework around discussing bias? Just curious to see if that work is going to continue at the FTC, because it appears that that's one good way to sort of gap stop if we can come to some kind of multi-stakeholder agreement around, what that looks like.
Great. Okay, 3 great questions. Giovanni, would you like to begin?
Oh, yes, thanks. You say questions. This is a $1 million question.
I know, it's true. It's how do you answer e-privacy?
But I'm happy to say that my advice, which is fully, let's say, developed in an opinion published on my website recently, and also in a couple of hearings I attended before both the Council and the European Parliament, is to work in a future-oriented approach, to have as much as possible few provisions only, to split data protection and privacy provisions from the telcos area, and to respect the new spirit of the general data protection regulation, the main one, according to which, as I said, there is much space for guidance. So I would not endorse any provision speaking in detail about specific technologies. So the principle of net neutrality is also relevant by different viewpoint. What I said, in my opinion, publicly available, as said, is that we should start analyzing the issue by the data subject viewpoint. If you navigate with your smartphone, in a couple of seconds, you go from TV to music, and then to other apps, and then to the web, and you go back to emails and social networks. It's so difficult to have a different privacy policy depending on the kind of application and tool you say. Second, the increasing difficulty in having let's say, a separation of policies concerning personal data and metadata. The notion of personal data, that's an announcement, will disappear soon, as well as the notion of anonymity. We will be increasingly identifiable, and therefore we have to consider the added value of metadata. What I consider essential in terms of Rubicon line is that we keep the current provision, which is already existing in the EU legislation, according to which member states should protect the confidentiality of personal data concerning electronic communications. This is essential. So we discourage them to now deal with encryption by provisions, let's say, focusing on end-to-end measures. I think we should analyze now the document to be published by the European Commission. So all in all is a pragmatic approach. What I encourage is that we focus on a limited number of provisions, limited, aiming at particularizing and complementing the GDPR. So consent, for instance, is a principle which is there, but then when applied to this area, you may have the need to specify how you manifest your consent. And if you have allowed me to say a footnote about the second question.
Quickly.
I was the chair of the working group who drafted the first telecom directive. It was 1997. And they said, okay, this is the last one. In few days, we have problem. Oh, is this applicable to internet? A lot of discussions, years of discussion. Then in 2002, we had a second directive, and they said, okay, it is applicable to standard internet services. No more updates. They started discussing immediately about social networks, search engines. In 2009, we had the third generation of rules, which has been amended accordingly in another stage. Therefore, what I encourage is that in terms of lesson learned, we focus on what is essential. So we have an obligation according to our constitution, which is the Lisbon Treaty, to identify a reasonable number of effective rules and then to focus on a proactive implementation. I think this is the way.
Thank you.
Good.
You want to address those two questions, the flexibility of laws in these incredibly dynamic spaces, and also Nicole's question about algorithms and bias?
Absolutely. So that is kind of goes to the heart of the issue here. Technology is evolving very quickly. There are new concerns that are raised, and then there are new ways to address those concerns. That is why I really like the FTC's case-by-case enforcement approach that is not requiring us to predict the future about what the new technology is going to be, but to say more, did you make a promise and you didn't adhere to it? Okay, you're going to be liable. Or is there a substantial harm to consumers that's not outweighed by benefits to them or competition, and that they can't reasonably avoid? So, for example, we brought a case, it was earlier this year, a settlement with Vizio. Right, Neil? That was the case, Vizio. Where there was this question about consumers not really being notified or kind of being deceived about the fact that it was collecting their viewing data and sharing it with third parties without their knowledge. And that was one of the questions. Is this something that consumers knew about? Did they understand that this was going to happen? There was some deception that, in the way it was presented to them. But I think, these new technologies keep coming up, but these same questions can continue to be raised. So that's why I really like the FTC's approach, that is the case-by-case enforcement. Now, your question about algorithms. So algorithms can be, they can be biased, and so can humans. Humans can be really, really biased and not realize it, or realize it and unfortunately continue to follow those biases. So I think what we need to look at for algorithms is, I agree with Julie, we can't see into the algorithm. That's too complex and it's changing too often. I think we need to look at what's going into it. Is it operating on a biased data set? And is it creating biased results that we have a concern about? So I think that is an appropriate area for us to continue to look at, but not so much as trying to get into the mechanics of the algorithm itself, because I just don't think that's practical.
So I think part of what Nicole was asking was, will the FTC be doing that going forward? I think you were asking, if I may, there was a big effort during the last administration. We were involved in the White House initiative, and we wrote a report. Will this be an ongoing conversation, at least as long as you can?
Yeah, no, I think so, right? I mean, we do enforce laws that are to protect consumers from you know, discrimination, and I think that's appropriate for us to continue to think about and to continue to be vigilant for.
Great. Well, will you all please join me in thanking Giovanni and Maureen for a fabulous conversation. Thank you.
Thank you all very much. That was really interesting.